Welcome to the Ports and Shipping News from Visakhapatnam. The government is engaged to pitch a legal battle in Supreme Court against the importers over its decisions to levy integrated goods and services tax (IGST) on the ocean freight on reverse charge base. With the tax authorities reportedly raising fresh queries even while the dispute is pending before the bench led by the Justice D.Y. Chandrachudi, importers are miffed. A hearing set for January 11 was postponed after two judges on the bench took ill. At the center of this spat are two notifications issued on June 28, 2017, levying IGST on ocean freight. The Gujarat High Court, which had in January 2020 declared the levy ultra-virus to the IGST Act, concluded that IGST on the ocean freight under the provisions of notification was not permissible in law. Ocean freight is the cost of moving goods internationally over sea to India. An agreement is entered into between two foreign parties, usually between an exporter and the shipping line, to transport goods to India. In its appeal, the government, represented by the Additional Solicitor General N.V. Venkatraman, has argued that the ultimate beneficiaries of the transaction is, however, the recipient of the goods in India, who is importing the goods on the cost, insurance, and freight (CIF) base. The government contended that the companies importing goods on CIF base are paying the freight directly or indirectly. Transport of goods which is carried out by the persons under that the importers himself is an active gives rise to aspect of providing transportation, and as such give rise to taxing incident descent from tax on import of goods. The government says the eventually recipient and beneficiary of the transportation service is the importer of the goods being taxed twice. Importer, represented by advocate Malik Manshibert, have countered that for the purpose of taxability, the service has been rendered in India to provide to an Indian. The service rendered by a non-Indian to non-Indian cannot be taxed merely due to the fact that ultimate benefit was reaped by an Indian as the goods have arrived in India. The importers have complained that IGST have been levied on them twice on the very same transaction by segregating portions of it. Importers, in addition to the custom duty, also pays IGST under IGST Act on the imported goods on value as determined under the Custom Tariff Act. This value includes the value of ocean freight, they argued. Thank you for watching. Have a nice day.